I'll wait about 10, 15 seconds and then we'll get started. The Supreme Court of Guam is now in session. Will the clerk please call the case?
This is Supreme Court case number CVA19-011. Florencio Harper, plaintiff appellee, cross appellant, versus Wan Sun P. Min, Edge Realty Inc., Pacific K&C Corporation, and Zhong Yi Inc. Guam, defendants appellants, cross appellees. Wan Sun P. Min and Pacific K&C Corporation counterclaim plaintiffs appellants, cross appellees, versus Florencio Harper, counterclaim defendant appellee, cross appellant. Wan Sun P. Min and Pacific K&C Corporation, third party plaintiffs, appellants, cross appellees, versus Zhong Yi Inc., third party defendant appellee. Appearing for the appellee, cross appellant, is attorney Thomas McKee Tarpley. Appearing for the appellants, cross appellees, is attorney Curtis C. Vandeveld. Appearing for the appellee is attorney William R. Mann. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Vandeveld reserves 20 minutes.
Good morning, counsels. At this time, Attorney Vandeveld, you are recognized.
Good morning. If it please the court, your honors. The issue that there are two issues that I presented in my appeal on behalf of my client. One is that even though there is this opportunity for the plaintiff to make an election as to which person against whom she will collect the judgment, I still argue that there is a requirement for the trial court to assess fault and liability as between principal and agent. And I believe that that is consistent with the cases that I've cited, most particularly with regard to the Fidelity Mortgage versus Ridgegate E Homeowners, 27 Cal App 4th 503. In that case, the court at what was Section B of the opinion states that a cause of action for indemnification can arise out of a principal-agent relationship. And in that, in the answer and third-party complaint, my client asserted a claim for indemnification. And so I believe that that put the issue properly before the court. I understand that Zhong Yi indicates that that was not sufficient preservation of the claim, but I believe that once the claim has been asserted, that preserves the issue. And the issue was before the trial court. In
Can I just ask a question? What was the trial court's basis for denying the indemnification claim?
I believe the trial court denied the indemnification claim on the basis of failure to have a business license, but I see the indemnification claim not as a affirmative claim made by someone who is engaging in business, but more as a defense. And all of the cases involving the business license issue deal with when a corporation comes along and makes affirmative claims. This is not an affirmative claim. This is a defensive claim that my client was entitled to make and should not be prejudiced by lack of a business license.
I thought the basis for the trial court's denial of the claim was collateral estoppel based on the other litigation.
If that's the case, then I think the issue is that regardless of whether or not the other case is resolving the contractual relationships between the parties. The issue of liability was presented squarely in this case. It was not an issue in the case which was CV739, which had to do with the termination of the contractual relationships between my client, Pacific K&C, and Zhongyi. And that was pursuant to a settlement agreement. There is an appeal of the decision in that particular case, but that case is stayed because of the bankruptcy proceedings of Pacific K&C.
And I know you cite the Fidelity case, and of course, Fidelity, I think, provides that as a general rule, an agent's entitled to indemnification by the principal for losses that are incurred by the agent in the performance or execution of their agency. But isn't there in Fidelity as well a discussion about the duty to indemnify only extending to an agent who's not barred by the illegality of the conduct of his or her own conduct? And so why would not PKC and Min, based on the judge's finding of fraud, be entitled to indemnification under the Fidelity case, when it's Fidelity seems to suggest that that indemnity does not apply to an agent who is engaged in illegal conduct?
I think that I understand exactly where you're going, but the discussion about that continues on to say, the second restatement, conduct to indemnify agent for expenses defending actions by third parties brought because of the agent's authorized conduct, such actions being unfounded but not brought in bad faith. The comment section 438 explains that instances in which the principal has a duty to indemnify its agent include those situations in which the agent has suffered a loss which may not have benefited the principal, but in which liability depends upon a conception that because the agent was performing the principal's business, it's fair that the principal should bear the incidental loss. And so my argument is that ultimately the performance of the functions by my client were based upon Zhongyi having engaged my client as an agent for it for the purpose of selling the properties and improving them for sale. The illegality would not have existed had Zhongyi performed what it represented and what the trial court found, which is that my client was awaiting Zhongyi having cleared the defect with the horizontal property regime, which it repeatedly represented it would do. Its failure to clear the HPR defect is what ultimately created the illegality and prevented my client from being able to transfer the property to Mr. Harper.
But Mr. Vanderbilt, the trial court found, in reference to following up on the misconduct of your client in making a finding that there was fraud in the inducement, that even with the knowledge that there was problems with the HPR, Mr. Lim went ahead and entered into this contract with Harper, knowing full well that the HPR filing had issues, and therefore that there was this fraudulent conduct. So even if the contention, that the argument you're making that, well, the fault lies with Zhongyi, and as to the reason why your client was not able to deliver clear title, knowing full well that this was the case, there was non-disclosure and that your client proceeded to execute the contract.
I don't think that's what the trial court found, that there was non-disclosure, because in the findings of the trial court found that the purchase agreement between Pacific K&C and Mr. Harper required that he, one, it put him on notice that there was a problem being able to obtain bank financing. The court clearly found that. And two, the court found that the document between the parties created the absolute obligation on the part of Mr. Harper to research, get a preliminary title report, to research the title and see if there were any defects, and to make demand if he wanted to, proximate to the time of the entry into the contract, which he chose not to do.
On my reading of the record and the findings of fact, the trial court determined that PKC and MIM committed fraud in the inducement in making the sale to Harper. So those, that was set out in the findings. And so I think just going further in terms of Justice Torres's pointing out in the Fidelity case that if there's a tortious conduct on the part of the agent, then the exception is that the right to indemnification does not apply in a principal-agent relationship. And I'm just then, if the trial court was in error in finding that there was an inducement, how was it in error?
Well, if you look at under the findings of facts and conclusions of law, Section 3, Harper's purchase agreement, it says at W, it says, the purchase agreement required Harper to obtain a preliminary title report and to report to PKC any valid objections to the title. If Harper reported any title deficiencies, PKC agreed to use due diligence to remove such exceptions before the close of escrow. Now, the escrow was not until the full payment had been made, and during that period of time, Zhong Yi had been representing that it was going to, within that period of time, clear the title to the property and resolve the HPR issue. So at the time that my client was inducing, I think that this factual finding is inconsistent with there being the intent to defraud Mr. Harper.
Mr. Vandervelde, Mr. Tarpley points out that in his reply brief that you failed to address his authority that the rescission has extinguished the contract. Therefore, your argument that Harper ignored his contractual duty to investigate the title is not logical, because there was no contract. The contract was void ab initio, and therefore there was no responsibility for him in the finding that he was entitled to rescission, which the judge had determined that Harper prevailed on his claim for rescission, that the contract was void ab initio.
I don't think that the voiding of the contract ab initio goes to the issue of the intent in entering into the contract, or whether or not there was fraud in entering into the contract. I believe that even though the remedy allowed for the rescission of the agreement, it does not otherwise alter that my client was simply relying upon information provided by the principal, which is Zhong Yi, about the ability to complete the intended transaction. And so I would say that my client was not in peri delicto, which I think is important, because my client was relying upon the representations made to her by the principal. So I would think that there should be an exception that would apply, because my client was not as much at fault, because she was relying upon, or it was relying upon, the representations persistently being made by Zong Yi. And what would happen is that if you don't allow my client to recover, then the party that ultimately had the ability to resolve what was the core problem in the ability to transfer the property, which is Zong Yi, escapes with no fault or responsibility for not having resolved an issue which not only affects Mr. Harper, but affects everyone within the subdivision and affects its duties and obligations to all people within the island of Guam.
I want to go back to the grounds for the trial courts denying the indemnification claim. For Min, the trial court determined that Min is a principal in PKC, but she doesn't have a separate claim for indemnification that's separate and apart from PKC. But there's nothing in your brief that addresses Min not being a party to the agreement and indemnification arising out of a non-contractual relationship. And you didn't order any transcripts for us to, examine the arguments that you've set forth. So how is it on appeal we're going to be able to look at this issue of Min's third-party claim against Zong Yi for indemnification when the trial court determined it on the basis that she didn't have a contract with Zong Yi? And then also PKC's claim for indemnification, as I asked earlier, and as the trial court determined, was collaterally estopped and dismissed without prejudice. And you brought up nothing, it seems to me, at least in the briefs that I read. You talk about this general rule for indemnification, but there's no discussion at all on why the trial court's finding of collateral estoppel was an error. So, I have a difficult time looking at what the basis of the trial court's decision was, which was collateral estoppel, non-contractual indemnity, and then your brief making the connection between the trial court's conclusions and what you're raising on appeal. So how did you preserve the challenge to the trial court's reasons for denying or barring the indemnification claims?
I believe that I preserved it by the filing of the complaint. I argued the matter before the trial court, and in the court's findings, the court concluded that my client it says, the court concludes that Zong Yi and PKC entered into a principal agent relationship when Zong Yi tasked PKC with renovating and selling the GVE, which is the Goring Villa estate units, for which Zong Yi would retain 110,000 of the sale proceeds, and PKC would retain amounts paid above 110,000.
There's no dispute about the principal agency relationship. I think I don't see anyone disputing that. I think the issue for me is that the trial court made a ruling, made a determination denying the indemnification claim for two reasons. One was that PKC was collaterally estopped and Min did not have a contractual relationship. And you point out that you argued against that, but you didn't order any transcripts from any of the arguments in the trial court for us to review where you made those arguments and the basis for those arguments. So I have a difficult time understanding how those issues are, how we're going to be able to review the trial court's findings of collateral estoppel and non-contractual indemnity when we don't have transcripts. You didn't argue those issues in your briefs. So it's tough for us to look at why the trial court was wrong when it made those rulings.
I've tried to express how I think that the issue is preserved and before the court, and I think that the issue, I believe that I did argue why it is that the court should make the findings, but I do understand what it is that you are saying.
I have one other question. Under Guam law, specifically under 7 GCA 24602, and when we're talking about rights of contributions, there is a specific provision that says there's no right of contribution in favor of any tortfeasor who has intentionally or willfully caused or contributed to the injury. So in this case, because of the issue of the trial court's findings of men's willful conduct, even if we decide we agree with you and there should be some contribution or joint and several liability instead of alternative liability, aren't you still going to be left with the same situation that you won't be able to get that contribution because of the specific provision in law?
I'm sorry, that you said 7 GCA section
24602C.
I'm sorry, I don't have that in front of me, Your Honor, but my argument is that relative to my client's actions, my client was at all times relying upon the representations that had been made to her by Zhongyi that the defect would be cleared. That is contained within the findings of facts by the trial court. And so I believe that my client was not in peri delicto with the actions of Zhongyi.
Who collected Harper's deposit? It was your client, right? Who possesses Harper's deposit?
Miju Realty. And that those amounts were included in the audit in CV19-011 and credited to Zhongyi.
Mr. Vanderbilt, would you like to reserve your remaining?
I would like to reserve the remaining time, yes.
All right. Mr. Mann, you are recognized. You have to unmute yourself, Mr. Mann.
Yes, Mr. Chief Justice, and may it please the court. In this appeal, Wan Sunman requests that the court remand the case to the trial court with instructions to enter a joint and several judgment against Min, PKC, and Zhongyi, and to determine their respective degrees of fault. The first point to be made is that Min never made such a request in trial court, either before trial, during trial, or after trial, and should not be allowed to make this argument for the first time on appeal. What Min did request in the trial court was indemnification from Zhongyi. The trial court rejected that claim, and it is frankly an absurd claim. Min fraudulently obtained $69,000 from Mr. Harper by misrepresenting that PKC was the owner of the subject property. That was a blatant fraud. When Mr. Harper discovered the fraud, he quite reasonably demanded that his $69,000 deposit be returned to him. Now, Min, as a real estate agent, was obviously required to return Mr. Harper's $69,000 to him. But her goal throughout this lengthy litigation has simply been to keep Mr. Harper's money. She has no right whatsoever to keep that money. Now, Zhongyi never received any of Mr. Harper's money. If Zhongyi was required to indemnify Min, then Min would have gotten away in effect, with her fraudulent goal of keeping Mr. Harper's deposit and being rewarded for this fraud. Once a man had this money, presumably still has it, she has no right to keep this deposit. And she got it only by fraudulently representing that that PK&C was the owner of property that it was not. And so, on a very fundamental level, this whole argument is absurd. She says that Mr. Vandervelde said that Miju Realty received it. Miju Realty is just a DBA of One Sun Min. So the trial court, the result of the trial court is necessary. The collateral estoppel ruling was a decision made in this case, in a different ruling prior to trial. There's no appeal from that. But in any event, the basic concept of Zhang Yi being required to indemnify, to actually pay money to Wan Sun Min, who has the money in the first place, and whose sin is not to simply return it years ago, is frankly absurd. Now, Min cites authority, I think it was the Fidelity or Ridgegate case, for a very unremarkable proposition that a principal is required to reimburse its agent for expenses incurred by the agent arising out of the agent's authorized, and I emphasized authorized actions, since that court used the term authorized several times. However, that rule certainly does not apply when the agent's liability is based on the agent's own fraudulent conduct, as here. There's no duty. The duty of a principal to reimburse the agent is when the agent incurs some expenses. For example, putting up a real estate sign in front of a house, paying for that, whatever expenses the agent incurs in carrying out the duty, but not when defrauding a third party. There is no basis to reward an agent's fraudulent conduct in that circumstance. Now, finally, and yet another ground to affirm the trial court's decision is the fact that under agency law,
but Mr. Matt, if there was not fraudulent conduct and an agent becomes personally responsible or liable for the performance of the contract entered into for the principal, isn't the agent entitled to indemnification under those circumstances?
Of course. The agent incurred an expense on behalf of the principal, a legitimate expense within the scope of the authority.
So what distinguishes that case from this case is the agent's own negligence, illegal acts, or other wrongful conduct.
Well, yeah, more than negligence, flat out fraud. Okay. And yes, that distinguishes very much, because otherwise the agent would, Zhang Yi is as much a victim of Min's fraud. Well, I won't say as much a victim as Mr. Harper, but certainly a victim by being forced into this litigation, because one reason only. Min refused and has refused for years to simply return the deposit to Mr. Harper. She's a real estate agent. That's all that she was ever requested to do, and what she has refused to do all of these years. So anyway, continue. Under the agency law, the liability of an undisclosed principal and its agent is not joint and several, but rather alternative. Now, Mr. Harper recognized this rule in his pretrial brief before trial and cited authority for that rule, and I discussed that authority in my brief. Mr. Harper properly...
Let me ask a question about that. It seems that more courts are leaning in terms of allowing joint and several liability instead of alternative liability in the principal agent context, understanding, of course, that the plaintiff can only be limited to one satisfaction of towards the judgment. What are the policy reasons for allowing alternative liability as opposed to looking at a joint and several liability when there's a undisclosed principal in the principal agency relationship?
Well, I would say that is California law, and we cite California authority. The policy behind it is, I suppose there's a dispute as to whether there's a principal agency relationship in the first place. And the rule seems to say the plaintiff, has an opportunity to prove or not to prove that there is a principal agency relationship. And if the plaintiff does prove, yes, there is a principal agency relationship and has two liable parties, the rule is stated that the plaintiff must elect. And quite frankly, I don't know the policies opposed to allowing joint and several liability, but I cited the authorities which do appear clear.
Mr. Mann, let's assume, just Doris points out, that there is an emerging modern trend, so to speak, and those jurisdictions are Washington, Minnesota, Maryland, and Ohio, that in this undisclosed principal agent principle theory, that instead of alternative liability, they recognize joint and several liability, so that the plaintiff is not left holding the bag if the person that they select is not able to satisfy the judgment. And so in terms of the policy reason, if we reach the issue, you said, I understand the argument, it's been waived. We decide we want to exercise our discretion and reach the merits of this argument because it amounts to some type of miscarriage of justice, assuming that's all the case. And we did have to decide, as in reference to what law should apply in Guam, what are the policy reasons for us to stay with the traditional approach, which, Mr. Harper argued in this case in terms of alternative liability? Or should we follow these recent set of jurisdictions that say that that's out? It's no longer really how the courts should proceed, and we should look for maximum remedy for the innocent party here, and joint and several liability and should be considered as the law for our jurisdiction. And let me just finish my question. You mentioned that California law is for alternative liability, but I also want to point out that we're not deciding this case on the basis of any interpretation of California statute. It's more in the it's more on the basis of principal agent relationship, which has and which in a de novo review, we are free to then not necessarily be persuaded by California law. That's a long-winded question, but what are the policies?
I respectfully suggest the court leave that question for another day in an appropriate case, because in this case, as I mentioned, Mr. Harper in his pretrial brief said, I recognize I have this obligation and I want to go forward to prove the agency relationship, which was denied by Zhang Yi. But Mr. Harper prevailed on that point and then made his decision. And during that whole course, at no point did Wan Sun Min object. That would have had to be brought up below. This argument about joint and several liability would have needed to have been brought up below, so this court would have the benefit of a trial court's analysis of that question. This court doesn't have it. That may be a question for the future, but this is not the appropriate case because there's no rule.
I understand that, and I went through the loops in saying there are a lot of steps that we have to take to reach the issue, assuming that we reach the issue, Mr. Mann, and I know the argument, your strenuous argument is that it's not this case because the argument has been waived. Yes, that Mr. Mim has not preserved the issue. But assuming we do reach the issue, what are the policy reasons why we may want to follow the joint and several liability or stay with the alternative liability theory in this area of the law?
I would suggest that there may be cases where a joint and liability would be appropriate, where there is fault on both the part of the principal and the agent. That case presents itself. However, and quite apart from not having this raised below, this is not the case, because here the fault is very simple in this case. Min took $69,000 from Harper and has refused to return it, regardless of the problems with the HPR and the like. I mean, Min knew that property couldn't be sold, but that was only one sin. The other sin was actually representing that PKC had authority to sell. She was trying to sell property she didn't own. And so even if the court were to say, in general, we can see where a joint and several liability would be appropriate between principal and agent, in some cases, I think the ruling would be it certainly would not be appropriate in this case when the fault is 100% on one side.
If we had to weigh the faults between Zhang Yi, your client, and Mr. Mim, then you have an argument. But if we had to weigh it between Harper and the defendants in reference to satisfying judgment, there may be a different analysis in reference to the benefits of trying to provide a remedy to the party that's been wronged, and in reference to who is more culpable. So I think those are some of the interests that are at issue here to be weighed. And I just wanted to know, in reference to your insight as to the policy reasons why it may make more sense in Guam that we follow these emerging trend of cases. So when you weigh all these different interests, who should be left holding the bag?
If I might add just one thing, Your Honor. Yeah, it is true that the absence of an HPR did generate a claim for PKC and Wansa Min. That claim was brought, PKC rather. That is the other litigation the court referred to. Okay, and that turned out, that's not part of this record, but that turned out the way it did. So in other words, Wansa Min had, or PKC had, a claim against Zhang Yi arising out of that defect, but Wansa Min is using that as an excuse not to return the money to Harper, and it's not an excuse for that. That litigation will turn out between PKC and Zhang Yi as it does, but it's no excuse not to give the money back to Harper. And so once again, this degree of fault whatever the court may think about joint and several liability and the sharing of responsibility, it's just not applicable to the facts of this case.
Thank you, Mr. Mann. I know that your time is up, and so unless the justices have any last questions for Mr. Mann.
I have no questions.
At this time, I recognize Mr. Tarpley. Mr. Tarpley, please proceed.
Thank you very much, Chief Justice. May it please the court. The appellants, who I will collectively refer to as Mrs. Min, they did not appeal the finding of fraud. Her two issues on appeal are: one, did the trial court err in denying claims for indemnifications from Zhang Yi? And two, did the trial court err in not determining the degree of responsibility of fault for each defendant? And Min's statements of facts on page 1 of her opening brief says the appellants do not dispute the factual findings of the court made in its findings of fact and conclusions of law. And on page 11, Min admits she overstepped her agency bounds by representing to Harper that KNC owned Unit 20. On pages 16 and 17, Min acknowledges the court's finding that she knew that Unit 20 could not be sold and that Min intended, I quote, intended to defraud Harper in order to induce reliance. So Min did not appeal any of this. She did not appeal the inducement. Instead, her appeal is a fight with Zhang Yi, not against Mr. Harper. So therefore, Harper took no position on Min's appeal. But Harper did cross appeal the trial court's finding that as a matter of law, Harper is not entitled to punitive damages for Min's fraudulent deceit because such damages are precluded by 20 GCA section 2120, which says, in short, quote, in an action for breach of an obligation not arising from contract, where the defendant has been guilty of fraud, the plaintiff, in addition to actual damages, may recover damages for the sake of example and by way of punishing the defendant, unquote. Now, Mr. Harper's position is that Min's fraud was to deceptively induce him to enter into the contract, and therefore the fraud did not arise from the contract, but was a breach of Min's obligation existing before there was a contract. And Harper's position is supported by the California case of Miller versus National American Life at 126 Cal Reporter 731, which holds that fraud in the inducement of a contract allows for punitive damages outside the California statute, which is identical to the Guam statute, which I just quoted. So Min's fraud was a tort upon which the contract was rescinded. And as Justice Torres noted, I quoted another California case that, quote, rescission extinguishes the contract, rendering it void ab initio, as if it never existed. Therefore, the trial court's decision on this issue should be reversed, should be remanded back for a determination of punitive damages and for attorney's fees for this appeal. Thank you.
Any questions for Mr. Tarpley?
Mr. Tarpley, under what theory is the party entitled to attorney fees?
She awarded the attorney's fees under the contract and under the Consumer Protection Act, which she also found that Min violated. It's in her findings.
So under
that wasn't contested by any of the parties, so I'm not have that at my fingertips right now.
So if punitive damages are awarded, then your contention is attorney's fees are due under the Consumer Protection Act.
Yeah, that was a determination by the court in which there has been no appeal. So that's the law of the case. And it was just a matter of law that we appealed because this fraud in the inducement did not arise out of a contract. It's an obligation not to do that before there was a contract. And so and the authorities that I cite for that uphold that.
But Mr. Tarpley, in remand, we don't have to address the issue of attorney's fees. That's already something that's recovered and has, as you said, not been challenged on appeal. And that's something separate that can still proceed. Is that correct?
Well, Your Honor, we were awarded attorney's fees up until the date of judgment. And under the rules of appeal, if we think we're entitled to further attorney's fees, we should state so, and I did in my brief.
Okay, I understand now. You're seeking attorney's fees for your fees subsequent to the award down below.
That's correct, Chief Justice.
All right, I understand. All right, Mr. Vanderveld, you are recognized in reference to the time that you reserve, and that's 9 minutes and 58 seconds, or the remaining time that's indicated on the clock.
I have one question, sorry, for Mr. Tarpley. I was going back to look at the trial court's basis for awarding attorney's fees, and I know it's not an issue on appeal, but if there is no contract and the trial court did award attorney's fees under the contract, does that eviscerate the claim for attorney's fees? I mean, obviously, if she did it under the CPA, it would still stand.
Right.
But you're the one that pointed out in your argument that if the contract is void ab initio, there's no basis to award anything under the contract.
Justice Torres, I will defer to the court's review of the record. Because this was not an issue raised, I haven't looked at that. I think the record stands for itself, the reasons why attorney's fees were awarded.
I think it was just more of a theoretical question because I'm looking at it and it does say that Harper was awarded for prevailing on his claim under the Consumer Protection Act, not under the contract.
All right.
Thank you.
Mr. Vanderbilt, you may take up your remaining time.
Thank you, Your Honors. So I've looked at 7 GCA section 24602C, which I pulled up on my screen while other argument was being had. And I believe a reading of the entire body of 24602, it is under C, the limitation of intentionally, willfully, or wantonly caused or contributed to the injury or wrongful death. I believe that the circumstances of P, K, and C were that it was, again, in reliance upon the persistent representations by Zhong Yi that the matter of the HPR, which prevented the conveyance of title, would be resolved before the last payment was made under the contract, which was the time under the contract for the closing to occur and for the transfer of title. And so at most, I believe that it was negligent, not willful and not wanton, and not intentional.
What about the representation that she owned the property?
The court found that as to that aspect, that the contract required Pacific K&C or required Zhong Yi to transfer the title to the intended buyer under their contractual relationship. So that was kind of it was a mistake, I think, but it was consistent with the contract in that Pacific K&C relied on the fact that it mandatorily was entitled to purchase the title to the lot for the $110,000, and that's in the findings of facts. And so maybe
what about the HPR issue? I mean, she knew at the time she entered into the contract that was not going to allow her to convey the title.
Well, that was my argument is that was something which Zhong Yi continuously represented, was they were in the process of clearing the HPR problem. And she had put Mr. Harper on notice about the defect by the fact of the findings that there was not commercial financing available, and by the provision of the contract that required him to obtain a preliminary title report and to exercise any rights of rescission based upon that. So I think that the circumstances are that there should be a redetermination of this issue. If the court is going to reject the contribution based upon a finding of intentional, willful, or wanton behavior on the part of Pacific K and C and thereby Min, I think that should have been a finding included within the findings of facts and conclusions of law. Otherwise, I think that the provision of 24602B is and A is in favor of my client, in that the trial court should have made a finding to the extent of which each party was at fault relative to the ultimate failure to be able to consummate the contract, which I think is also a part of the fraud in the inducement aspect. And so I believe that the appropriate requirement would have been for the trial court to make the determination. I also think that
That'll be a discussion if we're able to get over the hurdle, as pointed out by Mr. Mann, that you did not object to the imposition of alternative liability down below. And in fact, at the onset, it was raised in Harper's brief at the beginning, and that he suggested you didn't state to the trial court the grounds for that objection on the imposition of alternative liability.
As I said earlier, I believe that the claim for indemnification was the objection to the alternative judgment process, and that my client preserved that right by making the indemnity claim.
But Mr. Vanderbilt, just,
Yes, Your Honor.
assuming that your client waived the argument, did not preserve the argument, we also have a body of case law that provides for an exception under extraordinary circumstances, in which, in reference to just exceptional cases that will allow us to, even despite the absence of preserving the issue, why should we exercise our discretion in this case that makes it an extraordinary case to allow the argument to proceed?
I believe that the issue here presented about whether or not there should be contribution is something I have not been able to find any case law on this in Guam. The issue about the extent to which parties are at fault and contribution is an extremely important aspect of the civil law. And I believe that the court, if it finds that it has not been properly preserved, should, because of the importance of this issue and for future cases, I believe that the court should exercise its jurisdiction.
I mean, the standard is extraordinary circumstances where review is necessary to address a miscarriage of justice or clarify significant issues of law. I don't recall that this is an issue that has come up many times or even a few times in reference to alternative liability versus joint and several in the undisclosed principal circumstance. And so it's hard for me to see how we exercise our discretion in very limited circumstances should we agree that your client did not preserve the argument at the trial level.
I believe that even though this has not arisen in the approximately 27 years of the existence of the Supreme Court of Guam, the issue still is important because of the fact that while it may not arise in cases presented to the court, it relates to an extremely important legal issue upon which parties will make decisions whether or not to resolve their respective liabilities amongst one another. And I believe that the fact that it fails to have come to your attention doesn't mean that it doesn't have a significant impact upon the events occurring as between parties relative to civil litigation that may be presented at the trial court level. And so I believe it is a significant legal issue and should fall within the court's extraordinary relief. I also wanted to comment on that the issue of the fraud as reflected by Mr. Mann, that it's strictly somehow fraud on my client's part. The ultimate problem here was based upon the fact that the HPR, the horizontal property regime, was a matter which was exclusively within the knowledge of Zhong Yi at the time that it made the contract arrangements with my client and sent my client forward to solicit and obtain purchasers, and then persistently representing that it was in the process of clearing that HPR. And to say that somehow it is not substantially responsible for what ultimately did not occur or was able to be completed based upon the relationship with Mr. Harper really lies at the foot of Zhong Yi. So
Yeah.
I believe that, I'm sorry.
I will let you finish your sentence, Mr. Vanderbilt. I know that your time is up, but please finish the remaining part of your sentence.
Thank you. So really lies at the foot of Zhong Yi. And so if they escape responsibility, it induces people within the community to simply avoid responsibility by having an agent that they task to do their bidding, which they, at the time that they're tasking them for that responsibility, know they have no intention of completing. Because the ultimate authority to clear the HPR problem was not with Pacific K&C. It was not within the purview of Min. It was exclusively the province of Zhong Yi.
Thank you, Mr. Vanderbilt. And,
Thank you.
Council, so we want to thank you for your time. There are some novel issues in this case. And at this time, and we will take the matter under advisement, issue a written opinion at a later date. And at this time, the court stands adjourned.
Thank you all.
Thank you. Thank you, counsel.